Elon Musk recently withdrew his lawsuit against OpenAI. The question is, what does a withdrawal of a lawsuit mean, and what does it look like, and how does that affect your future claims you may have against a party? My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City, and today let's take a look at what happens when we have a case that ends before a trial, when we're withdrawing a case, and what it means for future litigation between the parties. So we found out that recently Elon Musk withdrew the lawsuit that was pending in California against OpenAI. It seems from the reports that at the time of the withdrawal, OpenAI actually had a motion that was going to be heard by the judge to dismiss the claim. So the question is, what happens when we have these early endings to lawsuits? So there was no trial, there was no big courtroom scene at the end. The case actually finished long before anything got started. In this case, it was because Elon Musk, the plaintiff, withdrew the case, but what the defendant, OpenAI, was trying to do is a similar way to end a case early, which is a motion to dismiss. So first, let's look at things from Elon Musk's standpoint. When we withdraw a lawsuit, there's two different ways to do it. The first way, and that's the way that Elon did it, is to withdraw it without prejudice. And so the word prejudice means whether or not you can bring claims again in the future. So in this situation, the news says that Elon withdrew his lawsuit without prejudice, which means he could actually refile the lawsuit, no matter what the claims were, no matter what happened in the case. Because he voluntarily withdrew it himself without prejudice, he would have the ability to refile the lawsuit, presuming he does it within enough time. And the time period is designated by your statute of limitations in your case, which is how long do you have to bring a lawsuit. So by withdrawing this case against OpenAI without prejudice, it means that although technically the lawsuit has gone away now, Elon still has the right and the ability to refile it again against OpenAI. The other way to withdraw a case is what we call with prejudice. And what that means is that you cannot refile the case later. You can't come back and make the claims again, and whatever was in your complaint that you were making claims, the issues, that's been withdrawn with prejudice. Now, when you're considering whether to withdraw your lawsuit or not, and you have to decide whether to do it with prejudice or without prejudice, a lot of it will be a matter of where you are in settlement negotiations with the other party. If you've come to a big settlement agreement, you've worked out all the issues, then chances are the settlement will say that the case will be withdrawn with prejudice so that the plaintiff can't come back and sue again after entering into a settlement agreement. Now, the news doesn't indicate why Elon withdrew the case and if there was a settlement or what was going on, but presumably because it was withdrawn without prejudice, there hasn't been an actual settlement entered into between the parties. If there had been, that withdrawal likely would have been with prejudice. Now, the second part of the story is very interesting because OpenAI had their own motion to dismiss the case that was going to be decided soon by the judge. And so what that motion says is, Judge, we've received the complaint and we don't think there's any merit whatsoever, and so we're asking you to dismiss the case. And when the judge decides to dismiss a case on a motion to dismiss, they face the same question. Are they dismissing it without prejudice or with prejudice? So if the judge dismisses your case without prejudice, which I see pretty commonly with pro se litigants, people representing themselves, they've created a complaint, they've brought a case, you're in front of the judge, but maybe it's not procedurally correct, or maybe there's a few things that can be fixed, a judge will often dismiss it without prejudice and explain to the litigant that they would have the right to bring the case again with proper pleadings. The danger you run on the motion to dismiss, of course, is that it's dismissed against you with prejudice, which means that you cannot come back and sue the person again on the same issues. All the things that you've submitted in your papers would be deemed dismissed with prejudice, assuming that's the way the judge does it. So I've also seen orders from a judge that say, I'm dismissing claims 4 and 5 with prejudice, but I'm only dismissing claims 1, 2, and 3 without prejudice, with leave for the plaintiff to refile the case. And so in that situation then, you can refile your complaint on counts 1, 2, and 3, but because 4 and 5 were dismissed with prejudice, you can't just file another lawsuit on those claims. So we may never find out, by the way, what happened that made Elon Musk withdraw the case, but it's a great example of why you need to understand the difference of with prejudice and without prejudice. Because a lot of times, if you are not careful for what you're doing and you work with a defendant and maybe you agree to withdraw your case with prejudice, you can be in for quite a surprise later when you wanted to bring another lawsuit and find out you can't can't bring that lawsuit anymore. If you have more questions about your lawsuit or withdrawing them or motions to dismiss, you can go to my website, andrewmayers.com. There's a red legal strategy session button at the top of the front page. If you click it, you'll be taken to my scheduling page where we can set up a 15 or 20 minute phone call. We can discuss your strategies for your lawsuit, we can discuss dismissals, we can discuss motions to dismiss, but we get those questions answered for you in a short phone call and figure out some next steps for you to take. If you like this video, you can hit the like or the thumbs up button below. You can always hop over to YouTube or AirsLawTV.com and subscribe for future episodes. And remember, if you're agreeing to withdraw your case, make sure you know whether or not you're withdrawing it with prejudice or without prejudice.